Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others aspiring to be them can follow in their footsteps.
Okay, welcome to another episode of Latte with a Lawyer. I'm your host, Jonathan Brickman, and today we have with us Kipp Cornell, who's an attorney with Cunningham, Meyer, and Vedrine in Chicago. Thanks for spending some time with us today, Kipp. How are you?
Thanks for having me. Doing good.
Excellent. So I know it's in the afternoon here, but to keep with the theme of the show, Latte with a Lawyer, what's your favorite beverage of choice?
Yeah, so that's a tough one. So in the morning I drink Diet Coke, so it doesn't quite have the ring as Latte with Lawyers. But yeah, I've never been a coffee fan. So if I'm drinking coffee, it's late in the day and I need a quick jolt. So it's Diet Coke in the morning for me.
Diet Coke. I used to be a Diet Coke addict, but I weaned myself off it.
I need to get there.
Anyway, all right, good. So listen, I read a little bit about what you do, but tell everybody about what kind of law you practice and how you got going here.
So basically, we're a litigation firm, but primarily we do medical malpractice defense. So we represent hospitals and individual physicians in the Chicagoland area. We have split between two offices. We're the downtown office, and we do have another office out in the burbs. So it's covers all of the Chicagoland area, which takes us to a little bit of Indiana and then some of Wisconsin.
Yeah, Chicago is a big place, so Chicagoland I know is a big area.
And there's no shortage of people looking to sue, right? So it keeps us busy.
There is no shortage. So is there anything more specific about what you do than medical malpractice? Any type of cases that you tend to work on?
So the way it's been shaped over time, and I don't know ultimately if it was meant to be that way, but given that our hospital clients have some of the bigger cases, had a fair amount of birth injury cases, brain trauma injury cases. They tend to be a little bit bigger, a little bit more involved, but also a little slower moving, right? So they take time, and it was never really planned to be that way, but as the practices evolve, those tend to be the cases that I've had the most of lately.
Okay. Well, I mean, it's fine. I was having a conversation with the other side of the fence on the plaintiff side that did medical mal, and there's a little bit of tension there, right? Because I mean, you don't work on contingency, whereas the plaintiff side does, right? And you're sort of the stewards of the client's capital.
Right. I mean, we have the benefit of, no matter what happens, ultimately we're going to get paid. And as the case, we still like to see the cases progress as fast as they can, but ultimately for us, it's, we just want things to happen correctly and get things done right. You can see a little bit of the tension that some plaintiffs want to move it. And the amount of money that goes into sort of funding these cases on both ends is it can be overwhelming to some individuals.
Oh yeah. How do you manage that though? Because there is kind of a built-in conflict there with the client, right? Because you are getting paid based on time, there is some sort of a financial incentive, right, to continue working on the case.
Absolutely. I think there is, on the defense side, there's still an incentive to move the case. The quicker you get fact witnesses and you get evidence done and discovery, the fresher it's going to be in their minds. In Illinois, it's up in the air whether it's going to survive constitutionality or not. If there was a Cook County case that ultimately determined it was unconstitutional, but that's going to have to be decided by the Supreme Court. We have this new prejudgment interest, which it's only been in place now for about 10 months, but that gives a little bit of extra incentive to all parties to move it because, we have this threat of prejudgment interest, which we never had.
What is that? Explain that, what that is.
So ultimately what happened was during the pandemic, the Illinois legislature passed a prejudgment interest statute, which with newer cases would start the prejudgment interest tolling when they were filed. With the older cases, it started when the date that the statute went into effect. And that you could there are ways to mitigate it by making offers, prejudgment offers. So it's an intricate statute. But the theory behind it, I think, from the plaintiff's bar who were pushing for it was that's going to move cases along because now there's incentive that should the verdict be for the plaintiff, you're going to now have an amount of interest that started to run from when it was filed, or if it was an older case from the date the statute was enacted. But again, whether that survives in the Illinois Supreme Court, we just don't know.
So when you say interest, you're talking about literally financial interest.
Yes.
Oh, okay. I didn't understand that. Interesting. Okay. That's interesting to put that mechanism in place to keep things moving.
Yeah. I mean, it was something that was pushed for hard by the plaintiff's bar. And so we'll ultimately see if it stays in place in Illinois. Got
it. Interesting. Is the firm focused exclusively on medical malpractice, or you do other areas of law?
We've done other areas of law. We've had some corporate cases that ultimately, if they were going to go to trial, so it may have been worked up by a firm that necessarily wouldn't be as comfortable, taking it to verdict. Less and less of those lately. I don't know why, but ultimately, yeah, it's been predominantly, I'd say 90% medical malpractice. Some other personal injury stuff. You may see it with clients that aren't related to the hospitals, or and sometimes the hospitals and physicians deal with personal injury stuff outside of medical malpractice.
Yeah, interesting. Is there a reason for that focus? The founding partners?
Well, it's how it sort of developed here in Cook County. So, the bigger cases, the cases that you want to take to trial, they tend to be, at least the high value ones on both the defense and plaintiff side, they tend to be the medical malpractice cases here in Cook County.
Okay.
So, we don't have caps on damages. There's an incentive for plaintiffs to take, some of these bigger cases to trial. And so really, the bigger cases we see in Cook County that are going to potentially make their way to a verdict, they happen to be medical malpractice cases. I
see. So you're trying to mitigate risk, right? So I see there's an incentive with no cap. There's going to be incentive to bring him to trial, right, for a bigger outcome. So what's your biggest concern with those cases? You got to make sure that you're limiting damages. How do you do that?
Yeah, so I mean, it's an interesting dynamic that's kind of, it's becoming more and more of a focus. Obviously, as defense attorneys, we want to not guilty, right? We want it to be completely zero. But you have to be really cognizant of the fact that, some of these verdicts are becoming astronomical. And it really focused a lot of us to shift to damages. It's hard because there's part of you as a defense attorney, you think, well, if I start focusing on damages, they may think I'm adding some sort of value or validity to their claim, right? I mean, I'm addressing liability, and now I'm talking about damages when I think there's no liability. But there are ways to do that, and we've had to develop ways to do that because it's equally as important. Obviously, we want to get a not guilty verdict, but it's as equally as important to, should it not go our way, because you never know what 12 jurors points do, to address damages, but address it in a way that the jurors know we're not conceding anything. So it's a focus that I think really started to shift, maybe at least here in Cook County, from the defense bar side, 5-6 years ago. I mean, because when you start to see $100 million, $50 million cases, you realize you have to put some emphasis on keeping the damages down should it not go your way.
Yeah. So is it fair to say that most are settling with some shared liability as opposed to, going for, no damages at all?
Well, so it's very case specific, right? I mean, the beauty of many of our clients here in Illinois is that, they have to obviously consider risks versus benefits, but they're also not afraid to try the correct case. Medicine is very difficult and is based in science. So that in and of itself, when you deal with 12 lay people, can be sort of scary or are a potential risk.
Right.
But we've got, some major medical systems here that are very proactive in saying, look, if the medicine is on our side and the case is truly defensible, we're willing to go forward, and we're willing to accept that risk because we believe in our medical care, we believe in our medical providers. And I think that's from the physician's perspective, that's very good for them to hear, because it can't just be a risk versus benefit reward. There has to be, at some point, I got to stand up for my physicians. And a lot of hospital systems here in the Cook County area or in the Chicagoland area, even if we get out of Cook County, are willing to do that. And they're willing to do that in the face of, there being a lot of risk. So on the flip side of it, they're businesses too, right? So they have to think about that, and they have to, at least explore potential ways to mitigate that should they need to. But it's a risky scenario, but it's also one that you kind of have to accept, right? You can't settle every case.
Yeah, it's tricky. So how many do you get the outcome where there are no damages from the defense side or your client? I mean, how often does that happen?
Well, so it happens all the time. So we've had two jury trials that I've been involved in the past 6 months, right? And the first one, a hospital system here and a neurosurgeon, and ultimately it was a not guilty and they got 0. We had a month-long trial with an emergency medicine physician in a hospital system here in Illinois, and they asked for a lot of money, more than $30 million, and they got 0. And again, a lot of that is, you've got to get credit to the physician. I mean, we had a physician that sat with us for a month, and a physician that would come and work with us on Saturdays late at night. And, that's our job. That's what we get paid to do. He's doing this away from his job. And it really kind of shows you the passion they have, because they have to sit there for a month and while someone attempts to criticize them, and they do that, and they go forward, and they truly believe in what they do. And I think there's a lot of credit that has to be given, primarily to the clients, because there's a lot of risk and there's a lot of work, and there's a lot of work that they don't necessarily get paid for because it's not their job.
Right.
It's a little bit easier for us because this is what we do.
You're getting paid. Yeah, well, the reputation. I mean, you don't want to have a suit against you right where you lose, because that's going to kill your reputation. Right. So I mean, there's a lot of stake there, I would imagine, for the physician or the healthcare organization.
Absolutely. There is for everybody. And so it's we've been blessed, at least sometimes you don't win everyone, but I could say we've been blessed with having, very good clients, and particularly individual physicians and hospitals that just want to do what's right and sort of work with us.
Interesting. So how do you prepare for that? I mean, I'm sure you're using expert witnesses. You've got, do you do focus groups and mock trials? How do you get ready?
Yeah, so it's really dependent upon the trial. It's focus group and mock trials. We do have some clients that love those, and they'll require them on most of their big cases. We have others that don't. The recent month-long case we had, we didn't do a focus group. The plaintiffs claimed they focus grouped it 3 times.
Yeah.
So ultimately, how much did that help them? But so we don't really do that too often, unless the client asks for it, and that sometimes does happen. But I mean, the workup of the case is kind of the beginning, and so much of what it takes to be ready for trial has already happened in the discovery phase, with the depositions, with hiring the experts. Hiring the right experts is one of the most important things. The most important thing is to have your doctor prepared, and if the jury views your doctor as somebody that they would go to as their physician, more chance than not you're going to win the case.
Oh, interesting.
But you got to back that up with good experts as well, right? So, the experts really are there to teach us, and a lot of that teaching is done before we ever get to the courtroom. And then when we get there, hopefully we have an understanding of the case and the medicine and our theory by that point, and then we use them to explain that to the jurors. And and sometimes it's very, very complicated. So to get an expert who's not only, great at being whatever specialty of medicine he's in, but they can take that and put it in a way that 12 lay people will understand it. It's kind of it's a delicate balance, right? You don't want somebody with a good CV, because they may or may not be able to explain things to lay people. So
yeah, you're relying on lay people, right, to make pretty heavy decisions on complicated matters, right? So you have to figure out the best way to communicate to them.
Yeah.
Right.
Yeah. It's not always about sort of being right scientifically. It's getting it to them in a way that they can absorb it and understand it. Because if you just tell them you're right and you don't really give it to them in a relatable way, they're never going to get there where you want them to get it.
That's right. That's exactly right. So how did you get started? Why did you become a lawyer? Tell me a little bit about that.
Well, so it's interesting. Like, just going back to sort of who I was growing up, I think ultimately I was a very argumentative child, and it was one of those things you just like to argue with my parents. I'd argue with teachers, and
debate, not argue. Debate. You were debating.
That's true. Just try to convince them that I was right, and that translated into I had a teacher who they were doing this youth court program in our junior high, and ultimately what it was they minors who were caught doing petty offenses, and it was kind of a deferment program. And in doing that deferment program, the prosecutors, the judges, and the defense attorneys would all be their peers, would be junior high students as well. They couldn't get anything serious like jail time, or it was all petty stuff.
Yeah, sure.
But it allowed us, the experience to be sort of real life litigators or judges, because sometimes you're a prosecutor, sometimes you're a defense. And so I did that, and then I was like, this is something that I think I really find interesting, and it sort of fits with who I am. And it was recommended to me because I was argumentative, which obviously sometimes a good thing, sometimes a bad thing, but it did kind of just fit. And so I thought, well, I think going into the law would be something I could do. And I didn't really know what else I could do, right? So,
yeah. Are you from Chicago? Where are you from?
I'm from Kansas City originally.
Oh, interesting.
Yeah.
Big family? Is that why you had to like sort of?
So I don't have that big of a family. So it's just me and my brother. And, we never had a lawyer in our family, but my dad was a police officer. And so we were involved with sort of the legal community in the sense that he had friends who were lawyers, and, some of the people he worked with, police officers.
You were on the right side of the law. You were
right. Well, had to be, right. If I'd have to come home to the police if I wasn't. So
that's right.
So yeah, and then
interesting.
From Kansas City, I sort of moved all around, and then I went to law school in Washington D.C. and I came back here.
Where'd you go to law school in D.C.? I lived in D.C.
I went to the Washington College of Law. American, yeah.
Oh yeah, I'm looking at it. Nice.
And so I ended up. The plan was I wanted to work for a court, and the court that I got a job with was a staff attorney here in Illinois, and then never left. Right, went up to Chicago, kind of fell in love with the city, and been here ever since, basically.
Yeah.
And as a Midwestern boy, it's the Midwest it's the simplest. So.
Yeah, no, I understand. It makes sense. I mean, Chicago's a great city. I've never been to Kansas City, actually. It's one of the places I have not been to.
It's not bad. When you live there, everything seems small, right?
Right.
It never seems big enough. So
yeah. No, I hear good things about it for sure. Let me ask you a question, because I'm sort of hinting at it, but what are there technologies that you use in your practice, and what's the view, what's your view and the firm's view of using it?
Yeah. So, it's funny, like when I started, 15 years ago with them, we were using, instead of using boards, instead of using Elmos, we were using computer software systems to put our records up in front of the jury. And at that time, I remember everyone thinking, wow, this is so technologically advanced. And, now we all do that. We've all moved past that to a little bit, to a degree.
Sure.
There's, computer software that you can use that's pretty similar, because all that hasn't changed that much. And then there's, you can do it with the iPad. We've become real big fans of demonstratives, and we use outside sources to do demonstratives, to video, and to give them sort of a picture of sophisticated medical issues and problems. As a society, we've become very screen oriented, and we believe it if we see it type people. And the demonstratives, I think, computer generated, really help the jurors understand things more than us trying to tell them, or even just seeing a static picture.
So you use like the medical illustration companies use that
We
software?
do.
You do?
Yeah. So we use medical illustration companies. We'll pretty much use, there's about 3 or 4 companies that our clients allow us to use. We use them. And they're all very good. We've had nothing but good things to see or say from the companies that we've been involved in. And then, from a technology side, basically from a courtroom technology side, what we've learned with the pandemic is, pre-pandemic, every now and then somebody would video conference in an expert or an out-of-state witness, and it was always frowned upon. And we just really did not, we always thought it'd be much more effective if they were there live. That's changed. The nature of it had to change, right? We had trials starting back up here in early last year or late last year. And so some witnesses couldn't come, and we were forced to use Zoom and to bring them in. And I think what we learned from that was, we had a trial in December where a plaintiff did that with one of their experts. And I think even they would agree, it went horribly. They didn't have the connection wasn't great. The setting wasn't, he should have been told to Zoom, it's got to be a professional setting. And so we kind of learned from that. And basically, I think we had the trial last month where we had to have an expert come in and via video. We had no choice, but we got a company that was going to assure us that, the Wi-Fi would be good. We got our doctor in a setting that looked very professional. And it worked splendidly. We felt like he was as effective, if not more effective, via the Zoom and via the screen than he would have been if he was there live.
So was it Zoom in the courtroom, or was it party material?
Yes. So it was Zoom. We Zoomed him into the courtroom.
Okay.
So, we've got a giant screen up there, and so they see him. And, with the software they have, we can have him half the screen, and we can have the records, or,
Oh, good.
he was a neuroradiologist. So if he's putting the films up, you can still see him, and he's there. And it worked great. And I think the lesson that we learned was you kind of have to plan in advance, and you have to get, so the problem with us in Chicago is they don't have Wi-Fi, very, very accessible Wi-Fi in the courtrooms here in downtown Chicago. And so you've got to get the right company. You've got to get the right Wi-Fi enhancer. You've just basically got to really plan in advance, and it will work great. But if you don't, it
works against you. Yeah.
It totally works against you.
Yeah.
And everyone now is Zoom. So everyone's done Zoom in some form or fashion. So when they see Zoom, when jurors see Zoom go horribly, they're like, what are you doing? I can work Zoom at home, Right. So it really is something you kind of have to plan for, but it can be very effective. And I think it's going to be something that we're all going to have to use more and more, but we just have to plan in advance.
Yeah. Interesting. I'm happy to hear that. So it is, you're a younger attorney, but I've talked to a whole range of people, but I think COVID definitely accelerated, fast forward a lot of the adoption of these things, but why not? There's huge advantages to take advantage of these things, for, again, as you said, most people consume information easier through video and illustrations than just talking. So.
Right. And it's hard as attorneys to adapt, right? We're all so used to it, and we all assume the way we were initially doing it was better. And I think, it's flipping it out of the courtroom for depositions, for some depositions, Zoom is great, for very important depositions with experts or with your own witnesses who are really important in the case, there is some benefit to being there with them. Yeah. But that's something that technology's changed. There's a lot of depositions, that we used to go to that we'll never go to again because we didn't need to. If they weren't that important to us, we don't need to be there live. The others with experts and stuff like that, I think we'll still be there with them.
Yeah. Well, that's the key. I mean, it's not one or the other. It's not all or none. It's, you sort of blend it in a way that makes sense where, you can sort of triage, right? The things that are less, right. That's why I think people get nervous about, with AI and lots of industries, like, no, they're going to eliminate our jobs. The reality is it's just augmented, right? So it becomes a support system and you leverage that in a way that makes sense to make you more efficient.
Yeah. And in a lot of ways, it makes our life a little bit easier, right? We still do what we do, just slightly easier and a little bit more complicated on the tech side. So
exactly.
Right?
Interesting. So what would your advice be today for someone that wanted to be a lawyer? Would still recommend it?
I would recommend it. I absolutely would. But it's funny. It's changed, and as time moves on, and as you sit back and you think about it, there was a period of time where we had a lot of attorneys coming in when a recession hits, right? A lot of people lose jobs, or they're having a hard time finding a job, and they go to law school just because
Sure.
It's an avenue where there's potentially a good paying job, but they really don't have a passion for it. They're just doing it because the other avenues weren't there. To those people, I would not recommend it, because you're gonna end up racking up a bunch of debt. And a legal education is great, and a legal education can allow you to do things outside the law. But do you really want to do that with all this debt that you're racked up? But if you have a passion for it, or if you think there's any way that there's any aspect of the law that you would enjoy going to, because at the end of the day, we have to enjoy our jobs, right?
Yes.
Then you should definitely go to law school.
Yep.
And if you change your mind at the end, if someone decides not to be a lawyer, in the end, that's not the worst thing, right? I mean, the training we get in law school to sort of problem solve and to think about things and in a way that, how do I make this work, or how do I apply my argument to get to a certain point, can be translated to any job. So if somebody were to change their mind about becoming a lawyer, it's not the end of the world.
Yeah.
And you can take that education to pretty much do anything.
Yep.
So
do you think you'll always stay on the defense side, or you maybe move to the other side?
It's tough to say. I think so. I mean, I think so, only because I don't know, working day in and day out with these medical providers, it really is a joy. And it's tough to see. It's the one profession where what you do on a daily basis can somehow be judged and nitpicked 4 or 5 years later. And so it would be very, very difficult to then turn around and sue those people, because we just had the benefit to work with so many great doctors, great hospitals, but I guess never say never, right?
Yeah, just curious. I mean, I've talked to some lawyers that have ended up making the switch from defense to the plaintiff side. I haven't heard anyone go for the other direction yet. So,
yeah, you don't see that too much. I think there is a mindset, to be a great plaintiff's attorney or to be a great defense attorney. And, the mindset of becoming a plaintiff's attorney, for me, at least at this point, is not something that I really feel like would be beneficial to me or to the clients if I became a plaintiff's attorney.
Maybe it's a personality thing. I've got to think about it. It could be related to sort of,
I think so.
Yeah.
There is a draw money wise, right, to the plaintiff side, because there's a potential for there's a potential for great riches. There's also potential to not make any money. So
right. I mean, listen, one is defense, and then you have the other side, which is probably more offensive, right? So you're right. There's a potential for a bigger outcome, I guess.
Yeah.
Anyway, well, listen, very, very interesting. If somebody wanted to get in touch with you and learn more about your practice, or, engage with you, what's the best way?
Email kcornell@cmvlaw.com or number 312-327-1939.
Excellent. Well, good. It's been a pleasure. And again, we had Kipp Cornell with Cunningham, Meyer, and Vedrine in Chicago. And this is hosted by EmotionTrac with a C, not a K. And we use artificial intelligence to glean insights from nonverbal communication that lawyers on both the plaintiff side and defense side used for litigation, for case preparation. So thank you again, Kipp, for spending time with us.
Thank you for having me.
Excellent.